Alrighty, capacity. So we're moving away from genuine consent to back to, in a way, validity in how the contract's formed. So if there's a lack of capacity, there's a lack of enforceability sometimes. So we know that a contract involves an agreement and intention to create those legally enforceable obligations. What the courts are holding is that if the parties do not have the capacity to enter the contract, one, they don't have intention, and two, they can't enter the agreement. So some examples of lack of capacity is someone that is mentally ill because they don't have the mental capacity to know what they're entering into. Similarly, intoxicated people are assessed in the same way. Basically, mentally ill and intoxication are the same thing. So if you're entering a big contract that you're a bit worried about, this is not legal advice. Get really intoxicated, sign it, and if it starts to go bad, I'm just kidding. Bankrupts have limited capacity. Companies is an interesting one for me because companies have all of the same powers as a natural person under Section 124 of the Corporations Act. So let's disregard that. Aliens are immigrants, but let's disregard that. Not important for us. Prisoners, and main one that we need to worry about is minors. People under the age of 18. Generally, under the common law, do not have... Actually, I should take that back. The common law said 21 being the age of majority. It's legislation that has reduced that to 18 in all the states. Lucky for us. So when you're faced with a mentally ill person, generally speaking, that mentally ill person will be, well, their affairs will be controlled by a guardian, someone that's appointed to undertake their business activities for them. But if there is no guardian, they've entered the contract, remembering that, well, I should know, capacity is a voidable issue. So the person that's arguing that they didn't have the capacity has to apply to court to have the contract cancelled. So it's up to the mentally ill person to come to court and show that they did not have the capability to understand the contract they were entering. And secondly, that the other party knew or ought to have known about their mental incapacity. There is a case in York Glass and Jubb where Jubb was suffering from mental illness and he's gone to purchase a business. He was later committed to a mental hospital and his guardians tried to repudiate or cancel the contract. Now the vendor at the time was unaware that Judd had this mental incapacity or illness and refused to accept the cancellation or the repudiation of the contract. So we've got a question here: is York Glass able to cancel the contract in those circumstances? And the court agreed that it could not be cancelled in these circumstances because the other party didn't know about the condition. So for mentally ill to result in the contract being voidable, you need to show, yes, that they had no capacity, but that the other party knew or ought to have known about the condition. So obviously in this circumstance, Jubb wasn't displaying tendencies of a mentally ill person when entering the purchase of the business, which meant that there was no knowledge of that condition. Bankruptcy also affects your capacity. Generally, if you file for bankruptcy, you'll have limited contractual capacity, and also these notification requirements that when you enter contracts, certain contracts, that you notify of your status. If you fail to notify in accordance with the regulations and law, the contract that you enter may be unenforceable. Generally speaking, we'll always have a clause in our contracts with individuals or companies that suggest that if they become bankrupt, that the contract terminates. And the reason that you do that is because their limited capacity to enter other contracts may affect the performance of the contract that you've entered into with them. And it's also a good idea to have as many exit clauses as you can, because if for whatever reason you want to get out of that contract, you've then got your opportunity. They've become bankrupt. With everything, if you're entering agreements with someone, particularly around financial matters, do a credit check. Get the permission to do it, check what their status is, and hopefully you'll have a long business relationship. Here we go, under the influence of drugs or alcohol. There is no distinction between intoxication and being mentally ill. The court holds them as the same accord unless you're a driver of a car. They're not going to give you the defence of being mentally ill if you're drink driving. Remember that. But in contracts, if you're intoxicated, you can apply to have that agreement repudiated. One thing about alcoholic, or not alcoholics, but individuals under the influence of alcohol, is that generally speaking, the person dealing with them will have at least some sort of understanding that that person is intoxicated. So in an assignment, look at the wording. Does it look like there's grammatical errors or any confusion in how the sentences may suggest that the other party should have known that the person talking to them wasn't in the right frame of mind? Hopefully that's pricked some people's ears up in terms of the research assignment. But with the under the influence of drugs, we have Blomley and Ryan. And we've got Mr. Blomley entering into this contract to buy Mr. Ryan's farm. And at the time of the transaction, Mr. Ryan was drunk. But not just drunk at this time. Mr. Ryan is a chronic alcoholic. So he's always drunk. Now, Blomley has entered into this contract for a price that is much below the market value. Ryan's upset by this and obviously wants to repudiate the contract because he's not getting his market value. So he's applied to the courts. Now the courts are holding in this circumstance that the contract was unenforceable because Ryan was incapable of forming a judgment at the time of entering the contract, and Blomley knew about this. So if there's a real ground for thinking that the judgment of one party was, to the knowledge of the other, seriously affected by a drink, equity, this is what this is, equity, will generally refuse specific performance and cancel the contract. There was also some real unfairness. You could almost go with unconscionable conduct as well here. There was a real unfairness in taking advantage of Mr. Ryan's alcoholic condition. So I've got awareness, taking advantage, and someone that was unable to enter a contract freely. Contracts with minors, this is the big one. Generally speaking, an individual who is under the age of 18 cannot enter into a contract. Generally speaking. So contracts with minors are unenforceable, and the public policy around that is to protect the minor. But there are exceptions, and those exceptions also protect the minor, because if there weren't these protections, no one would sell anything to a person under 18, because you would never be able to enforce it. So these exceptions are, if the contract is for the supply of a necessary, I'll explain what a necessary is, and or a beneficial contract of service. Now what a necessary is something that you need to sustain your life. Food is a necessary, clothes, education, the type of things that you need to sustain a condition of life But that condition of life is relevant to the context of the minor themselves. So if it's a 17-year-old that's got a really good job in an accounting firm, a suit or multiple suits might be necessary. Whereas an individual who's 14, attending high school and for whatever reason needs no suits, may have a harder time proving that the suit was necessary in that circumstance of life. In my opinion, everyone should have a suit, but it depends on whether it's necessary in that person's station of life. So what we look at is, firstly, is the thing capable of being necessary? And is it necessary for that particular minor? Wayne Rooney signed a contract as a 16-year-old. And the question was, I'm not sure, it wasn't Man United, it was another football team, Everton. And he wanted to get out of that contract because he was a minor. So it does happen. And is a football contract necessary? I'll have to go back and revisit that case because I forgot what happened, but... It was? Yeah. So that's Wayne Rooney's career.
So just a question, as an accountant, if you did a minor come up in Australia, you can work when you're 16 and 9 months. So if you're 17-year-old come in the office and say, can you do my tax return? Is the tax return deemed by the government as a necessity for a 17-year-old?
Yep, so if the 17-year-old is required under law to submit tax returns, we could call it a necessary. But you're right, that minors are employed at 16, 9 months. And those contracts are okay because they're of a beneficial service. But generally speaking, it would be very rare that a minor would be successful in these type of capacity cases. But the law is, as it stands, like this. Yeah.
Similarly, in the football scenario, players are often scouted very young. So let's just say if we take the Rooney case, he was 16 years old. So the guardians are held liable for the responsibilities and the remunerations of the contract.
Yes. So that's a good point in terms of when you've got minors, what do you get on top of that? Parental guardianship approval. Good thinking. So we have the case of Chappell and Cooper, which is a sad case, because we've got a widow, but they're both minors. In 1844 it was okay to marry at that age. And the widow has refused to pay for the funeral expenses of her husband that's just passed away. And she's arguing that because she's a minor, she doesn't have to pay. So the question is, are funeral expenses necessary? And the court said yes, luckily for this funeral home. Although things of luxury will not always be considered necessary, funeral expenses are a part and parcel of life. Unfortunately, it's a reality for us all, but funeral expenses will be, at one point in time of your station of life, something that will need to be paid for. So what they're saying there is that luxury items are generally excluded, but luxury items of utility are not. So gold, for no reason, is a luxury item, but gold, in terms of a ring maybe for the funeral, is gold for a utility of purpose and allowed.
So in insurance, or if you know insurance for a minor is a necessity.
Insurance would probably be necessary.
Insurance, funeral insurance.
Yep, you could claim funeral insurance. So the concept of necessaries is quite broad. A lot of things fall within things that are necessary for us to live. And let's have a look at Nash and Inman. Now, the child here is actually very wealthy. He's the son of a baron. He already has a number of good suits. He gets some more made, gets some top-line clothes made, cufflinks with diamonds and things like that. And in 1908, the question was whether that purchase was something for a necessary. And the courts are saying, well, if you've got multiple suits, enough suits for your situation, would it be unnecessary to purchase another one? If it is unnecessary, the minor can refuse to pay for the suit and could cancel the contract. But note that that's not all bad for the person that sold the suit, because if the courts hold it like this, they may not have to pay, but they have to return the suit. So then manufacturer is not all that lost, so long as the guy hasn't gone partying and put holes all through it. Education isn't necessary, but it's in context of the situations that we're looking at. So we've got Charlie, a 17-year-old, who's bought a suit from Danny for $1,000. Now Charlie's wanted a suit so he could get an interview for a job as a sales representative. Now Danny sent Charlie the invoice and Charlie's refused to pay. Can Danny enforce the contract? And we look at the IRAC methodology. Can Danny enforce the contract for the sale of a suit to a minor? That's the issue. And the rule is Charlie being under 18 means that these contracts are usually unenforceable, with two exceptions: supply of a necessary or it's a beneficial contract of service. And that's where that tax return will come in. It's a beneficial contract of service to the child. So firstly, who agrees that a suit is capable of being a necessary? Yep. Do you think it's a necessary in this particular case? Yeah. So there's some strong arguments to suggest that it is. There's no evidence in this fact pattern that Charlie has more than one suit. A question that you might be able to flip yourself on though is, I like suits, but is a $1,000 suit necessary for a job interview? Probably not. Oxford sells suits for about $300, $400 sometimes. I know that's something on sale. But that's your point of argument. Yes, suits are necessary generally, but the price in this question may bring into question whether it's necessary for this person. So it's arguable, but you can go either way. In what case would you use? Nash and Inman. Excellent.